Welcome. My name is Gerald Newman, and I'm the director of the Human Rights Program here at Harvard Law School. And I want to welcome you to Keeping the Promise, the Children in Armed Conflict Agenda at the United Nations. We're here to discuss United Nations efforts to hold accountable both states and non-state parties to armed conflicts who inflict egregious abuses on children, and what can be done to improve those efforts. For that purpose, we have convened an extraordinary group of experts. To briefly introduce them, Alan Rock served as Canadian ambassador to the United Nations in New York during a period that involved responding to several complex regional conflicts. He is president emeritus of the University of Ottawa and a former professor in its faculty of law, where he taught international humanitarian law and armed conflict and international law. Joe Becker is the advocacy director of the Children's Rights Division at Human Rights Watch. As the founding chairperson of the International Coalition to Stop the Use of Child Soldiers, she helped campaign successfully for an international treaty banning the forced recruitment of children under age 18 or their use in armed conflict. Benyam Dawit Mezmor is the Eleanor Roosevelt Visiting Fellow at the Human Rights Program here at Harvard Law School. He's professor of law at the University of the Western Cape in South Africa. He served as the Special Rapporteur on Children in Armed Conflict of the African Committee of Experts on the Rights and Welfare of the Child, and he's a member of the Committee on the Rights of the Child. Originally, Professor Yang Hee Lee was supposed to be a member of this panel, but unfortunately she's not been able to join us. And she's kindly shared some speaking points that the other members of the panel will try to address. For the audience, let me say, we will be having a question and answer period after the panelists have spoken. There's a Q&A function at the bottom of your screen, which you can use to submit questions. And I will try to ask as many of them as I can. There will be a notice in the chat function about how to sign up for the newsletter of the Human Rights Program if you'd like to learn more about our activities and other events of this kind. And finally, the recording of this will be made soon available on the Human Rights Program's YouTube channel. Before we start, I'd like to thank our co-sponsors, the University of the Western Cape in South Africa, the Dullah Omar Institute, and here at HLS, the Program on International Law and Armed Conflict, and HLS Advocates for Human Rights. So to begin, could I ask Benyam, why is this topic important, and why is a discussion of this nature timely? Can you help us set the scene?
Thank you very much. It's a pleasure to be able to join this panel and respond to some questions. The topic that we're dealing with today, children in armed conflict, it's a very highly connected one. It's very difficult to think of any provisions, substantive provisions within the Convention on the Rights of the Child that is not violated as a result of armed conflict. Now, there is some very compelling research by a number of organizations. I'm going to single out one. For instance, there is research by the Research Peace Institute Oslo. For example, in 2021, they said that approximately 449 million children, that basically means more than 1 in 6, were living in a conflict zone. While this number has decreased for the first time since 2013, there is bad news as well. It seems that the subset of these children living in areas of high intensity conflict has actually increased. In 2021, again, Africa was the world region with the highest total number of children living in conflict zones, around 180 million children. Followed by Asia. So it's very clear to see the concentration in terms of geography. The Middle East, unfortunately, continue to have the highest share of children living in conflict zones, which is around 31% of children. So the evidence shows that too often children are far from being on the periphery of violence during armed conflicts. Killing, maiming, recruitment and use, abduction, sexual violence, attacks on schools and hospitals and so forth are sadly far too common. The second point that I just want to emphasize is the legal framework. It's a topic that is standing on a relatively solid international legal framework. So the notion of legal gaps and so forth as being a barrier to implementation is not as pronounced and should not be as pronounced as it is the case in a number of other areas. For instance, the area of children's rights and digital media. The issue traverses international human rights law, surely, international humanitarian law, international criminal law, and even labor law. Now, the third point that I just want to highlight is that the Sustainable Development Goals and our collective efforts to actually achieve them are squarely connected to how we manage to address the issue of children in armed conflict. Questions abound, for instance, how the international community can achieve zero hunger by 2030 without addressing children in armed conflict-related issues. Goal 3 on healthy lives, or Goal 4 on education, or even Goal 5 on gender equality. They are fairly and directly connected to the issue of children in armed conflict, which requires a higher level of attention. The fourth point that I would be remiss if I don't mention is the link between conflict and climate change. There is no shortage of superlatives and expressions about climate change. The one that I often find compelling is the one that says the defining issue of our time. The evidence again shows that the worst impacts of climate change, fragility, and conflict often overlap. Currently, the world is facing a food shortage crisis, partly because of the Ukraine crisis. We are currently talking about 800 million people who actually go to bed hungry. And out of these, 190 million are in very precarious situations, close to the level of emergency. So the connection between food insecurity, climate change, conflict remains a primary driver of food insecurity. And it has, for instance, forced 139 million people in 24 countries. And these are staggering numbers. Now, in relation to the UN's work, I want to focus, for instance, in what is being done in Geneva. We often talk about the UN, about the fact that the UN actually has 3 pillars for its work: human rights, peace and security, and development. The children and armed conflict agenda traverses all these 3 fairly squarely. We know that some have argued that, yes, peace and security and development are the 2 pillars, but the human rights is not really a 3rd pillar. It's very much more of a 3rd stick. These criticisms might be extreme, but they're not necessarily completely off mark. If you look at the budget that is being allocated for the issue, there is quite a lot of room for improvement. In relation to some of the work in Geneva, let me single out just 2. The work that is being done by the Committee on the Rights of the Child within the human rights treaty bodies and the special procedures. The Convention on the Rights of the Child is a very solid instrument, 196 member states that have ratified. The Optional Protocol on the Involvement of Children in Armed Conflict has 172 ratifications. There's still some remain that need to ratify: Somalia, Zambia, Iran, Liberia, Lebanon, and Haiti, and few more. But relatively, one concern is that the initial reports, in terms of the implementation of the Optional Protocol, there are around 38 initial reports that are overdue, and that's definitely a concern. In relation to our engagement on the basis of the state party reporting process to the Committee on the Rights of the Child, we have highlighted a number of more obvious issues, but also less obvious issues, but equally important ones. For instance, when France came to the Committee on the Rights of the Child, the sexual abuse cases in the Central African Republic were highlighted. We have had countries that are not necessarily going through armed conflict, but issues pertaining to international cooperation, the issues on migration, accountability, efforts to assist disarmament, demobilization, and reintegration issues are highlighted by the Committee on the Rights of the Child. The special rapporteurs, or within the special procedures, for instance, the special rapporteur on Central African Republic or Myanmar, or a number of even commissions of inquiries have highlighted children in armed-related conflict issues. To conclude, the agenda is very critical. It has a number of cross-cutting elements. We don't have the luxury to catalog just the challenge without also underscoring the potential way forward. So these are some of the reasons why this is important, and this conversation is critical. And as it will unfold, there are a number of intersecting issues that we plan to address in the conversation.
Thank you. Joe, could you describe how the UN Security Council first took up children in armed conflict, and how the agenda has evolved. What do you see as its biggest successes?
Thank you, Jerry, and thanks to Harvard Law School for sponsoring this webinar this morning. And it's nice to see a number of friends and colleagues on the participant list, and I'm looking forward to the discussion. So the UN's Children in Armed Conflict agenda really goes back nearly 30 years. In 1993, the UN General Assembly asked for an in-depth study on the impact of armed conflict on children. That study was conducted by Graça Machel and revealed how profoundly children were impacted by war, whether it was being recruited and used as child soldiers, sexually, subjected to sexual violence, injured or killed by landmines, displaced from their homes, or affected by other wartime abuses. The report was really a wake-up call. And the General Assembly responded by requesting a special representative to the Secretary General on children in armed conflict, specifically to follow up the report and to advocate on behalf of children in war. Now, in 1999, the UN Security Council decided that violations against children in war constituted a threat to international peace and security. And since then, it's adopted a dozen resolutions over time that have created an architecture that is really unlike anything else at the UN. And it has several key components. One of them is an annual list issued by the UN Secretary General that gives the names of parties to armed conflict, both governments and non-state actors, that are responsible for grave violations against children. Now, initially, the list was focused solely on the recruitment and use of child soldiers, but over time, it has expanded to include what we now call the 6 grave violations: child recruitment, killing and maiming of children, sexual violence, abduction, attacks on schools and hospitals, and the denial of humanitarian access. The current list includes more than 60 governmental forces and non-state actors that are responsible for violations. We often call it the list of shame because no one wants to be on it. The second critical component is what we call the monitoring reporting mechanism, the MRM. This was requested by the Security Council for UN teams on the ground, together with NGO partners, to collect and verify violations against children, to ensure that the Security Council and the Secretary General were receiving credible and accurate information for the Secretary General's annual reports, and to be used as the basis for the list and for action by the Council. The third component is the Security Council's Working Group on Children in Armed Conflict. This is an entity that exists primarily to look at country-specific situations, assess the violations that children are experiencing, and to make recommendations for action. And then finally, I want to highlight action plans. The Security Council has said that every party on the list of shame should negotiate an action plan with the UN to end its violations. And it has also mandated the UN country teams to engage with parties in order to negotiate these plans. The plans can be really specific. For example, on child recruitment, they might call for command orders to go throughout the chain of command to make clear that child recruitment is unacceptable. It calls for the release of children from the party's forces. It may require the UN to give the party to give the UN full access to camps or barracks to verify whether or not our children are present. And I think here is where we have seen the system's greatest successes. Over the years, 38 action plans have been signed by both non-state actors and governments alike. 12 parties have fully implemented their plans and have been taken off the list of shame. This includes, for example, the government forces of Chad and Uganda, the Maoists in Nepal, other non-state actors in Sri Lanka and the Philippines. Currently, 18 plans are under active implementation. And over the past 20 years, partly as a result of these plans, nearly 200,000 child soldiers have been released from armed groups and forces. So I think, these successes really helps show the UN at its best and how it can really have impact for children most affected by war and why this agenda is so precious. Thanks, Jerry.
Thank you. Alan, with regard to this list, can I ask, are there criteria for listing and delisting? Can you explain how and why the list was split in 2018 and what has been the effect?
Jerry, first of all, I join with my colleagues in thanking you and the Human Rights Program at Harvard for hosting this important discussion this morning. In terms of criteria, Joe just went through the list of grave violations, so-called, that are prohibited in the context of children in armed conflict and that are relevant to the list. In 2009, the Security Council asked the Secretary General to provide criteria to explain what would guide the Secretary General's decision on the question of whether to list a party or delist a party. And in response, the following year, Secretary General Ban Ki-moon laid out criteria, which more than anything else were intended to convey the thought that it would not be isolated individual incidents that would lead to listing, but rather it would require patterns or recurrent conduct. And so the Secretary General's effort in laying out the criteria was to reassure that what he was looking for were not individual actions which might occur, but rather a series of actions, a number of actions, whether it was in relation to attacking schools and hospitals, sexual violence against children. So that was the basis of the criteria published in 2010. I might add that when we published our report a year ago on the way in which listing and delisting decisions were made in the decade from 2010 to 2020, our group was focused on whether those criteria were adhered to, and we found often they were not. I could also add that the criteria are rather vague. There's no detailed definition of what is a pattern of grave violations involving sexual violence or attacks on schools and hospitals. So the criteria were there, but they were rather vague. In terms of delisting, when the Secretary General was asked in 2010 to explain criteria for delisting, he was a little clearer. He said, in order to escape the list of shame, a party had to enter into an action plan, had to fully satisfy the provisions of that action plan, and for a period of at least 1 year, the monitoring and reporting mechanism had to certify that the party had not engaged in any of the prohibited conduct. So those are the criteria for delisting. In terms of splitting the list, this really gets us into the broader discussion of what's been going on at the United Nations in this context. In 2015, 2016, Secretary General Ban Ki-moon was under enormous pressure from the Saudi government to delist it from the list of shame. The Saudis threatened to withdraw funding, reportedly, from the United Nations and its programs if their names were not taken off the list. And the Secretary General removed the name and explained that the whole matter would be under review. It was a shameful period for the United Nations. It was a difficult period for the Secretary General. And it was an event that called into question the integrity of the whole program that Joe has explained so well. After all, if someone can get their name removed from the list of shame by threatening reprisals against the United Nations, then what's the credibility of the list? And what is its value? So it was really an important threat to the integrity and effectiveness of the whole system. When the current Secretary General took office in 2017, he also was under enormous pressure not to list Saudis, not to list certain other governments who exerted influence upon his office, trying to stay off the list of shame. The list suddenly was split in two. There was the regular list, and then there was a separate part for those parties to armed conflict who had taken so-called positive measures to protect children in conflict. Now, this was an innovation which was not provided for by the Security Council's resolution establishing the monitoring and reporting mechanism. It was a finesse that was created by the Secretary General in order to relieve the pressure he was feeling, brought to bear by some member states to get their names off the list. And if you were on the second part of the list, namely that you were taking positive measures to protect children, notwithstanding your conduct in the field, then that was some measure of comfort. So it mollified those who were critical of the list. And it got the Secretary General, or so he hoped, past the critical pressures that arose every year when the list was published. But there's never been a rational basis or a legal basis for that division of the list. Never been a clear explanation of what these so-called positive measures are. And in some instances, there's been complete absurdity where parties are moved to the buffered part B, where they're taking positive measures, notwithstanding the fact that in the previous year, they'd been responsible for a higher number of child casualties than before. So it was an innovation which was a regrettable dilution of the list, a weakening of this important tool for the protection of children. And one of the recommendations we made last year in our report is that that division of the list should be ended. We should go back to the list as first intended by the Security Council, so that we have the full effect, full positive effect of the list of shame, as we try to use it as a tool to influence the conduct of those engaged in armed conflict for the protection of children.
Thank you. Benyam, can you tell us more about this eminent persons group? What led to its establishment and what has been its mandate? What were your principal findings and recommendations? What were your, how have the recommendations been followed? And were any changes made by the United Nations following the eminent persons group report?
Thank you very much, Jerry. In my response, I will build on some of the points that my co-panelists have also highlighted. So the eminent persons group was convened by Watch List on Children in Armed Conflict. It's a global network of human rights and humanitarian organizations which strives to end violations against children in armed conflicts and to guarantee their rights. The group included, as was mentioned, myself, Alan, Professor Yang-Hee Lee, but it also included Lieutenant General Romeo Dallaire, who most of you would know, but he's the founder of the Dallaire Institute for Children, Peace and Security. And of course, he's the former force commander of the UN Assistance Mission for Rwanda during the 1994 genocide. And the mandate that was provided to us was straightforward. The mandate was to conduct an independent review of the Secretary General's listing and delisting decisions from 2010 through 2020. In light of the evidence that has been documented in the reports, and provide our conclusions and recommendations. And we do believe that that's exactly what we have done with no fear or favor. Now, some of the findings have been highlighted, and I'm not going to belabor them, but let me just highlight a few more. The point about the listing and lead listing criteria has been mentioned. The additional finding that we had was parties that are not listed despite high numbers of violations. That was very critical. For instance, in Afghanistan, international forces and the Afghan National Defense and Security Forces have each been found responsible for killing and maiming hundreds of children since 2014. Yet neither has ever been listed when we did the assessment. We also looked at the issue of inconsistencies in listings between parties in the same country. For example, the Democratic Republic of Congo, the Allied Democratic Forces, ADF, it's a non-state armed group, was first listed for killing and maiming in 2015. although the annual report did not specify the number of children killed or maimed by the group in that reporting period, in subsequent years, ADF continued to be listed, with the number of verified child casualties attributed to the armed group reported to be 20 in 2016, 19 in 2017, and 9 in 2019. So that's very positive news and progress. However, another national state armed group, non-state armed group, the Kamwina Nsapu, was found responsible for the highest number of casualties, killing and maiming at least 31 children in 2018 and 45 children in 2019. But it was not listed. We can also talk about other examples. For instance, in the Philippines, the Maute group was found responsible for 13 cases of recruitment and use in 2019, but was not listed. By contrast to the Maute group, the New People's Army, another non-state armed group in the Philippines, was listed with 5 cases of recruitment and use that specific same year. So this double standard definitely, as the EPG, drew our attention, and we provided some findings there. The other element is the disparities in treatment of states and non-state actors. Now, I'm going to give a couple of examples. For example, in Iraq, in Somalia, even in Yemen, government forces have been found responsible for committing a high number of violations without being listed, while non-state armed groups have been listed for a similar number of violations, suggesting the two types of groups are held to somehow of a different standard. That's not what we perceive to be the principles, the rules under the Convention on the Rights of the Child. That's not what we perceive to be the principles and the rules under the Optional Protocol on Children in Armed Conflict, but also that's also what we perceive to be the rules under international humanitarian law. The last point that I want to mention in terms of the findings, the inconsistent application of the criteria for delisting was absolutely critical, and we provided some guidance there. Our assessment, for instance, reviewed 21 instances where parties were removed from the annexes between 2011 and 2020. In 6 of those instances, parties were delisted because they had ended violations and implemented action plans in line with the Secretary General's 2010 criteria. In 8 instances, parties were removed from the list because they had ceased to exist. In 4 of these instances, parties were removed from the list because they had integrated into other armed forces or armed groups who continued to be listed. In the remaining 3 instances, our findings showed that parties were delisted in contravention of the criteria that was set out for delisting in the Secretary General's 2010 annual report. And these 3 cases, which we highlighted in the report, provide some guidance on the way forward. Now, in terms of the recommendations that we provided, we tried to classify the recommendations into different categories. The first one is in relation to the UN Secretary General, that he needs to hold the perpetrators of grave violations of children's rights to the same standard, regardless of whether they are government security forces, a coalition of governments, armed non-state actors, or even peacekeepers, in line with the Security Council Resolution 1379. We also talked about the delisting criteria. We also talked about ending the distinctions between sections A and B. And we also asked for a clarification how the UN actually determines whether a party to a conflict has engaged in a pattern of grave violations of children's rights, and ensure that such determinations are made according to consistent criteria going forward. We also provided recommendations to UNICEF and the Task Force on Children in Armed Conflict to continue to actively support the Secretary General and the Secretary General's Special Representative on Children in Armed Conflict with technical advice and field analysis. We provided recommendations to the SRSG on Children in Armed Conflict to work actively with the Secretary General to ensure that the list of perpetrators of grave violations against children in the subsequent report, that was 2021, and in the future is more credible, objective, and evidence-based. We also emphasized the role that actually member states play. Alan was talking about the pressure and inconsistencies and so forth, including member states of the Security Council, also those that are group of friends on children in armed conflict, and also those who support children in armed conflict, and some of the roles that they should play, that they should press the Secretary General to adopt these recommendations that we provided. Request that Secretary General transparently report to the Security Council whether there have been any change in the listing or delisting criteria, but also to support the monitoring and reporting mechanism to collect and verify information on violations. Now, in terms of to what extent they've been taken on board, I'm just going to highlight, we're still concerned about a number of developments, including in the recent report, but at least, for instance, in 2021, as the EPG, we said we acknowledge the limited progress that has been made to hold perpetrators in other conflicts accountable for abuse against children, namely, for example, the listing of Somali government forces for rape and other forms of sexual violence against children, and the Afghan National Army for killing and maiming children. We also welcomed, actually, the relisting of the Tatmadaw for recruitment and use of children in Myanmar, which we believe is a necessary measure to correct the premature delisting of the Myanmar security forces for this violation that happened in the previous years. But again, there is still quite a lot of room for improvement, which I believe we will be able to engage on. Over to you, Jay.
Thank you. Joe, can I ask you to say more about the impact of politicization on this list, on the effectiveness of the monitoring and reporting mechanism? What has been the impact of counterterrorism agenda on the children in armed conflict agenda at the UN? How has the UN dealt with emerging conflicts, including those involving groups designated as terrorists in relation to children in armed conflict?
Thanks, Jerry. Yes, I'm happy to build on what Alan and Benyam have already described in terms of the list. The disparities and the double standards that they've described have had two key effects, I believe. One is very practical. You know, if a party is not on the Secretary General's list, the list of shame, there's very little incentive for it to change its practices and to end violations. And if no other party in that country is on the list, it also means that there's no monitoring and reporting mechanism to collect information on the violations that are happening. And then finally, if a party is not on the list, it also means that the UN country team has no mandate to engage in negotiations to try and achieve an action plan. So that's the practical effect. And then the second effect is that it simply undermines the credibility of the whole system. If parties perceive that governments in particular that are powerful or that have powerful allies can get a pass despite serious violations against children, they're going to take the process less seriously. Let me give a recent example. Last year, the Secretary General's report indicated that Israeli Defense Forces were responsible for over 1,000 cases of children being killed or injured in Gaza and the West Bank. Now, this was a larger number than any other single party listed or discussed in the report. And yet Israeli Defense Forces have never been included in the list. So when other armed groups or governments see this kind of, exceptionalism, you can hardly blame them for seeing this whole system as being rigged or even, seeing it as a joke. It certainly also encourages, other governments or armed groups to use whatever influence they have and follow the examples of others to try and pressure the Secretary General to stay off the list. And I think it's really important to emphasize that this list is the backbone of the entire system. And when it is politicized, the entire mechanism suffers, including, children on the ground. Now, turning to your other question about the impact of counterterrorism, I would say that, one critical principle of the Children in Armed Conflict agenda is that children who are recruited or who become associated with armed groups as child soldiers are to be regarded principally as victims. And the priority needs to be their rehabilitation and their reintegration into their communities. So in many countries, we've seen really important programs to help children reunite with their families, get back in school, get vocational skills, and become, contributing members of society. But when it comes to conflicts where groups are designated as terrorist groups, we're seeing a very disturbing trend. Instead of providing children with rehabilitation help, children are being locked up, detained, and even being prosecuted as terrorists. This is something that I've personally researched in Iraq and in Nigeria, where children have been detained in large numbers and even tortured for suspected affiliation with either ISIS or Boko Haram. So in Nigeria, for example, nearly 4,000 children have been detained as suspected Boko Haram members. I spoke with one boy who was only 5 years old when he was detained, and another who was picked up simply because he sold yams at a market to Boko Haram members. The Secretary General's most recent report indicates that nearly 3,000 children across 20 countries are currently being detained solely for alleged association with armed groups. And this is a serious step backward from some of the principles that I think are really very important to the agenda. But, one thing to note is that to their credit, the Secretary General, the Special Representative to the Secretary General, and the Security Council have all spoken out on this trend and have really urged governments to use detention, solely as a last resort. And more recently, to adopt handover protocols to ensure that any child who has been apprehended during the course of the conflict is immediately transferred over to civilian authorities for rehabilitation assistance. And then, sorry, Jerry, what was the final part of your question?
How the UN has dealt with emerging conflicts.
Yes. So yeah, this is the last issue I wanted to flag, is that one challenge that comes up is what happens when a new conflict emerges. And in the last few years, for example, we've seen very serious conflicts erupt in the Tigray region of Ethiopia, in Mozambique, and notably in Ukraine. And in fact, in some of these countries, the violations go back a number of years. In Ukraine, we were seeing attacks on schools, for example, as early as 2014. But a question that's emerged is, how do these new conflicts get integrated into the UN's Children in Armed Conflict agenda? And one thing that's been disappointing is that the Secretary General has been quite slow to include these new conflicts in his report. So, for example, the three that I've named will only be discussed for the first time in his 2023 annual report, which means that parties that are responsible for really grave violations against children are likely to not even be listed until 2024. And, for children who are suffering the brunt of these horrific conflicts, that's just, far too late. And, I think reflects a bureaucratic approach that's just not in the interests of children or in international peace and security. Thanks.
Thank you. Before I ask the next question, I just want to say this will be the last question I'll ask to the panel for the presentation portion of the program. Questions are coming in on the Q&A. Let me encourage other members of the audience who'd like to submit questions, that it will soon be time for me to turn to the audience questions. So with that said, can I ask Alan, we've just heard some reference to the conference in Ukraine, to the conflict in Ukraine. Russia is a member of the Permanent Five group on the Security Council. Russia is involved in the conflict in Ukraine. Russia is involved in the conflict in Syria. What are the implications of this group of facts for the even-handed application of children in armed conflict protections and tools?
Well, Jerry, if there was ever a test of the integrity of this system, of the principle that listing should take place without fear or favor, and that all parties to conflict should be dealt with even-handedly, that test will be presented with unprecedented importance in the context of Ukraine. We've seen in the last, since February 24th, the spectacle of a permanent member of the Security Council breaching the most fundamental principle of the Charter, namely that war of aggression is prohibited, and yet remaining on the Council as a permanent member. We've also seen numerous credible documented reports of attacks on civilians, including children, attacks on schools and hospitals, maternity wards by the Russian forces since February's invasion. And of course, it's nothing new, because we saw attacks on civilians by Russian forces in Crimea since 2014. And we've seen Russian forces attacking civilians, including schools and hospitals in Syria, since their involvement in that conflict in 2014. So the question will become, is there a special category for the P5? Are they to be insulated from accountability? Are they to be accepted from this system because they have the power of veto, because they're a permanent member? And of course, there is no basis in law, logic, policy, or reason for any such distinction. It comes down to raw power. It comes down to the influence of a permanent member. So as Joe mentioned, Ukraine is finally going to be a situation of concern, a subject of the report next year in terms of the evidence being gathered, with the prospect that measures will be taken by the Secretary General pursuant to the monitoring, reporting, and listing system in the following year. But, you know, the events since February have put into, I think, a focus that's really without precedent. The question whether the United Nations can continue in its current form, or whether there has to be change, structural change, to overcome the absurdity of the 5 permanent members and their special status, and the lack of representativeness in the Security Council. I think that what we're seeing emerge in terms of the children and armed conflict agenda in Ukraine involving Russia and its conduct will simply amplify those concerns. You know, we've spoken this morning about the importance of this listing mechanism having integrity, credibility, and we've spoken also about the principle that the protection of children should be a politics-free zone. Well, we're about to find out whether that's the case in the context of Russia in Ukraine. There can be few clearer cases of grave violations against children than those committed by Russia over these past many months, and indeed past many years in Crimea and Syria. So we're now going to come to the final round of this test to determine whether the integrity of the system can be preserved, and that remains to be seen. Indeed, the future of the Security Council and the United Nations remains to be seen in that context.
Thank you. If I can turn to the questions from the audience. One of the questions is, as a way forward on listing, would there be value in ranking all countries to ensure consistent monitoring of violations against children in armed conflict around the globe, rather than selective examination of situations? Who would like to answer that?
I'm happy to pick that up. It's an interesting idea, but it does raise questions about, you know, what would be the criteria that we use to rank the countries. And I think Alan has already, you know, spoken to some of the challenges, even with the criteria on whether a party should be on the Secretary General's current list or not. And, you know, the best criteria for the current listing is, you know, is the party committing a certain number of grave violations? You know, Alan said it needs to be more than a trivial number. It can't be just sort of incidental. It needs to indicate a pattern. But, you know, that's the best measure. But then if you dig deep into what a ranking would look like, then, you know, if you're just talking about one violation, for example, killing and maiming, you could do a list based on the numbers of casualties. But we're looking at 6 grave violations. So then how would you compare, for example, acts of sexual violence compared to child recruitment or compared to killing and maiming, you know, and would you weight one more heavily than the other? And I don't think we want to get into that kind of exercise, because all of these violations are very, very serious. So, you know, the idea is interesting, but I think it would be really difficult to implement. So, you know, my own view is that the current system, if it's evidence-based, if it's objective, can be very effective, but we need to sort of get back to principles and make sure that it works the way it's supposed to.
Thank you, Benja.
Thank you very much. I fully agree with Joe on all counts. A very interesting idea, but we will actually, if we were to move in that direction, we will be diluting the role that the list has been playing for a large number of years. It also comes down to the Convention on the Rights of the Child and the Optional Protocol on the Involvement of Children in Armed Conflict. The convention, one of the strengths of the convention is that it actually combines both civil and political rights and economic, social, and cultural rights. These conversations that we're having in relation to the 6 grave breaches, they are actually grave breaches. We can talk about deprivation of liberty, we can talk about child marriage and a whole range of other things that are not yet being used for the purpose of listing. So it risks diluting, it risks compromising the solid legal basis that we have under the Convention on the Rights of the Child, as well as the Australian Protocol, but also under international humanitarian law. So I don't also believe that as an idea it might be interesting, but I don't believe it's a way forward.
Thank you. The next question comes from an audience member who is anonymous, but is a UN staff member working closely on the MRM at the field level. The question asks, the Security Council resolutions and the whole process are an acknowledgement that grave violations against children bear on international peace and security. In the current dynamics, the Secretary General and the Special Representative do not seem to use the mechanism and tools of the agenda as designed. In your opinion and analysis, is this approach purely due to susceptibility to political pressure, or a belief that there is another, better way to address grave violations? A belief that grave violations aren't actually that relevant to international peace and security, or other factors? And what can member states do about this?
Well, perhaps I can address that. First of all, I think it's important to acknowledge the work done by UN staff on the ground in gathering evidence in relation to the monitoring reporting mechanism, sometimes under the most difficult and indeed dangerous circumstances. Evidence is gathered with scrupulous care, is verified and re-verified, and then presented to the mechanism co-chaired by UNICEF and the most senior officer of the UN in the country in question. So the evidence that's gathered is very reliable. I first of all want to acknowledge and express gratitude to the person who asked the question if they're involved in that process, a very difficult and exacting one. As to the question itself, I guess it's a matter of speculation whether the principles of monitoring, reporting, and listing have been departed from by the Secretary General and his special representative because they believe a different approach is better to preserve international peace and security. My own view, I don't think it's that complicated. I think what's at work here is political pressure. And political pressure has influenced the decisions on listing and delisting. And it's as simple as that. And we have to get back to an approach which is based on evidence, which, as I've already said, in these cases is very reliable, and which involves an even-handed objective determination whether a party should be listed for the benefit and protection of children. I believe that the mechanism which is in place is very sound. It was created for a specific purpose, which is to protect children in armed conflict and to influence parties to respect them. And it's effective, as Joe has pointed out. So I think we should stick to the basics. implement what the Security Council has authorized, do so in a system which has integrity, and achieve the purpose which was intended in the creation of the mechanism in the first place. That would be my response, Jerry.
If I could just add to the last part of the question, which was what can member states do? First, I want to say that every year the Security Council has an open debate on children in armed conflict where any UN member state can make a statement. And we've been gratified that in the last few years, a number of countries have used that venue as an opportunity to reinforce the importance of a credible list and to urge the Secretary General to make his list objective and fact-based. And we also know of some instances where member states have approached the Secretary General directly, privately, or his special representative to raise concerns about the disparities and double standards reflected in the list and to really urge a more evidence-based approach. This kind of intervention is really important, and we hope that member states will continue using, all of these avenues, both public and private, to continue to reiterate how important a credible list is, and to continue to send that message. Thanks.
Thank you. And Benyam.
Very much. To complement as well. So the listing and delisting, absolutely critical. Politicization manifests itself in different ways. I'm just going to single out two. One is the budget cut that has been happening in the last few years in relation to child protection officers, gender-related officers, in a number of occasions, collapsing of positions. And this human rights worker who's actually on the field, rolling up his or her sleeve and facing quite a lot of these issues, often in a number of occasions at a personal risk, they need to be supported as much as possible. And part of it is the issue of budgets. So we've seen it in the context of UNAMA, United Nations mission in Afghanistan, where paragraphs on child protection were cut in discussions in New York. Peacekeeping missions in the process of negotiations for budgets have also cut positions pertaining to child protection and gender-related issues. MINUSCA is another example. UNAMID is another example. So the politicization itself manifests in a number of ways, shapes and forms. One of it is in relation to budget cuts, which needs to be looked at very closely and addressed. The second point that I think needs to be highlighted is also the role of individual member states. I know that we talked about Russia. I want to single out another state, which is the United States, and their role in terms of international cooperation and so forth, and the important role that they play for accountability. One issue that we have engaged with as the Committee on the Rights of the Child is the idea of presidential waivers. So the United States actually provides full or partial national interest waivers for purposes ranging from political considerations to supporting counterterrorism operations and so forth, so forth. For instance, in 2013 and 2017, the Committee on the Rights of the Child expressed concerns about waivers granted to countries where reports from the UN had indicated the recruitment or use of children or other related grave violations of the rights of the child in the context of armed conflict were present. These were waivers pertaining to, for instance, the Democratic Republic of Congo, or Libya, or Rwanda, or South Sudan, and so forth. That definitely needs a very closer look. The third element, which I think our colleague Yang Hee Lee has shared with us, is that we need to look at the listing and delisting within a broader lens as well. What are the connections? She singles out a very important element. She said when she was special rapporteur, she looked into peacekeeping operations. And actually, she discovered that 4 Tatmadaw were in the UN peacekeeping operations. This was in 2018, after the Rohingya genocide. She said she actually raised the issue and repeatedly follow up on it. And luckily, they're no longer in the program. And she highlights that it would actually be a good idea to check the peacekeeping operations list of participating countries from time to time to make sure that those that are accepted are actually not on the Secretary General's list. And this is one aspect that we need to pay close attention to as we talk about the different forms that politicization manifests itself.
Thank you, Benyam. And I just want to associate myself with the view that concern about politicization in favor of P5 should address all of the P5 and not only some of them. There's a question here that asks, it seems like there are quite a few countries that do not feel affected by being placed on the list. We see how countries are relisted repeatedly, for example. How are we to ensure that these countries truly adhere to their obligations? And then the question says, on child soldiers. But I suppose I'd like to phrase that question more broadly to the extent that you think that's appropriate.
Maybe I can start. I think it's a great question, because when we look at the perpetrators that are included in the list, we have a really broad spectrum. You know, on the one hand, we have government armed forces that, you know, can be expected to be more sensitive to international criticism and censure. On the other hand, we have a whole range of different non-state actors. Now, in some cases, these non-state actors may have a very clear political agenda. They want to show that they are a credible force that could be a legitimate governing, you know, party in their country. In other cases, you have, you know, NSAs that really don't care at all about international opinion or their reputation. And so the listing, you know, to be honest, may not work in every case, but I think there are a significant number of governments and non-state actors alike that do care about their reputation. They do want to be able to show that they can conduct themselves, you know, in a responsible way in situations of armed conflict, and know that as long as they're on the list of shame, it really, you know, undercuts their claims to legitimacy. And so we have certainly seen, you know, both governments and armed groups alike, you know, enter into negotiations on action plans or take concrete measures as a result of being listed. And one thing that's notable is that, you know, people sort of, the reflexive opinion is often like, oh, of course this is going to work for governments, but it will never work for non-state actors. But in fact, there are more non-state actors that have signed action plans as a result of being listed than there are government forces. And quite a number of those parties that have been delisted for complying with their action plan is, you know, are non-state actors. And so, you know, I think, you know, we need to try whenever we have, you know, traction, whenever we have some good arguments with parties on the list, to try and use that leverage and get them to sign and implement an action plan.
Thank you. Another question, it has been some years since the establishment of the 6 grave violations that determine the list. Do you believe it might now be time for an evaluation or assessment of the 6 grave violations, taking into account the evolution of armed conflicts, as well as overall change in the world's environment, in order to either add to or modify them? Benyam?
Thank you very much. It's a very important question, and I'm alive to some of the issues that are raised in this context, for instance, within the African Union, including within the African Committee of Experts on the Rights and Welfare of the Child. There are few issues that are more important and maybe more important to some regions than others, or some countries than others. For instance, the issue about conflict-related trafficking or conflict-related you know, child marriage and so forth have been highlighted as being important to benefit from their own individual assessment and to be listed on their own. One point that Joe has briefly touched on earlier is the issue of deprivation of liberty, detention. Even though, for instance, the Special Representative of the Secretary General on Children in Armed Conflict also has actually continued to report on it, I feel that we're still tinkering at the edges. There is so much information that is needed, that we need to engage states with. For instance, I know a number of African countries who have clearly said, no, we don't have any children that are deprived of their liberty because of their association with X or Y, but after that public statement, the evidence actually showed that there were a number of children that were deprived of their liberty. So detention issues pertaining to child marriage, I think, are issues that need to be looked at very closely, which also links the issue to the role that regional organizations should also play. The African Union, obviously the one that I know very closely, comes to mind. And over the years, there has been significant progress in placing emphasis on some of these issues. I remember when I started more than a decade ago as a member of the African Committee, there used to be just only an open day on women in conflict. And then we used to be invited to make a remark and so forth. And later on, we started, the African Union Peace and Security Council started a process where there was an open day on children in armed conflict. It almost became a standing agenda item on a yearly basis, and that has continued. So those conversations should definitely lead to these peculiar issues for the region, child marriage, detention, and so forth, to also feed into the conversations that are actually happening at the United Nations level, including the UN Security Council. So I do personally believe that the time is now and the place is here to actually have those reflections in terms of what should feature as being an add-on to the 6 grave breaches. Thank you, Jay.
I would just add a note of caution. I think it's important always to keep the list current so that it reflects the reality in contemporary conflict. But we've already talked about budget cuts, about lack of resources, let alone lack of political will. So yes, while in principle, I think we should review the list to make sure it reflects the true dangers that children face in armed conflict. I think we should also focus on the 6 grave violations that exist and making the current mechanism work with integrity. So yes, let's monitor and see if additional violations should be added, but let's not lose sight of the fact that we have 6 grave violations which are of enormous importance, and that our monitoring and reporting and our listing mechanism should be the first priority in relation to those, to make sure that we're achieving the fundamental purpose.
And if I could add just briefly one other thing, Benyam mentioned that even though it's not considered one of the 6 grave violations, the Secretary General does systematically track the detention of children for alleged association with armed groups. There's another issue that the Secretary General is also systematically tracking, even though it's not a grave violation, and that's the military use of schools. And I think this is a phenomenon that has become more recognized in recent years as something that puts children at risk and deprives them of their right to education. And so, you know, we do see a lot of data that the MRM has been collecting on this issue as well. Thanks.
Thank you. To pick up on the resources issue, one of the questions leads me to phrase it in terms of, is there a need to address funding challenges that face the implementation of action plans signed by parties to armed conflict to end and prevent grave violations against children?
There have always been funding constraints, and in many cases, implementation of the action plans don't necessarily require financial resources. They just demand political will and accountability. But I think one area where we really do face constraints on resources is rehabilitation and reintegration of former child soldiers and services for girls in particular who have been victim to sexual violence. And this is a real problem. If there isn't funding available to provide, children with healthcare, with, schooling, with vocational skills, especially for former child soldiers, there's a real risk that they will just rejoin armed groups as a way to sustain themselves and make a livelihood. So, maintaining those resources is really important, not only for the stability of not only for these children's well-being, but the stability of the communities and countries as well.
Benyam, do you want to add something?
Briefly. One of the points that I think it's a very important question, and thank you very much, Joe, for reflecting on it. One of the linkages that we also need to make between the resource shortage and the current reality that we're working with is the COVID pandemic. Quite a lot of these countries that I've already listed earlier are in Africa, are in Asia. They are struggling because of foreign debt, because of the effects of climate change, because of food insecurity, which is being coupled with the armed conflict. So the opportunity to actually allocate resources, let alone for monitoring and reporting, but also for some of the basic things is increasingly becoming difficult. So there is a much needed resource need that is being created as a result of the pandemic. This also relates to education. The pandemic, we were already facing an education gap. We used to talk about the education gap. As a result of the pandemic, we're currently facing in a number of these countries what we call education gulf. The gap is no more there, it's actually a gulf. And again, the resources are needed much there. Now, the third element in relation to COVID that I think I should mention is, because of the pandemic, we've also faced a number of challenges on monitoring and reporting, on verifying. I know of cases within Africa where troop rotations could not happen because of the rules pertaining to freedom of movement and so forth, which inevitably affected the monitoring and reporting mechanism, but also the verification. So it is inevitable that the resources that are needed to actually catch up on some of those challenges that we faced as a result of the pandemic in the coming few years are going to be even much more. But unfortunately, at the UN level, we're in reverse mode. As I highlighted earlier, in many of the resolutions that are being adopted in New York, there is a debate about not just only in the substantive processes, but also in the budget processes where cutting of budgets and so forth is happening. And that doesn't really bode well with the current environment within which the children and armed conflict agenda is operating.
I have a question that asks about what regional organizations can contribute. The OSCE as an example, or other regional organizations with regard to these problems.
Well, I think they can play a very important role. And as Benyam has already mentioned, whether it's in Africa or in the Americas or in Europe or Asia, I think regional organizations have to be engaged in this agenda for the protection of children. The influence they can bring to bear on governments that are involved, the political, economic, and other instruments available to them as leverage to affect the behavior, particularly of state forces, whether it's through sanctions or diplomatic or economic measures. I think those are very important. And also the whole question of monitoring and reporting, the gathering of the evidence, their cooperation and involvement in all of that, in addition to their support for the broader protection agenda generally. So yes, I think that none of this is going to succeed unless we have regional organizations that are committed and that are taking practical and effective steps to try to achieve the objectives that we all share. So I fully agree that regional organizations have an important role to play.
Daniel?
Thank you. Very briefly to speak on the regional organizations issue. First, the SRSG's special representative of the Secretary General on Children in Armed Conflict also appreciates the added value that regional organizations play. For instance, a couple of years ago, the office opened another office in Brussels to engage there. There have been MOUs with the African Union and so forth. So that's a very important and positive development. The second important element that I want to highlight, which again relates to the African Union, is that there is a very solid legal basis on addressing the issue of children in armed conflict within the African Charter on the Rights and Welfare of the Child. So it should not just only be the Convention on the Rights of the Child and the Optional Protocol International Humanitarian Law, but also in the instances where regional instruments like the African Children's Charter provide a higher standard, a more conducive environment, they need to be tapped to actually address the issues on children in armed conflict. The third element, regional organizations are playing a more prominent role in peace negotiations, in peace building and conflict resolution. So they also play a very important role when these negotiations are being done to include elements in those documents that deal with addressing gender violence, addressing the children in armed conflict related issues, addressing issues pertaining to disarmament and so forth. And fourthly, I think regional organizations could also play a very important role on accountability. We've seen it within the African Union. The African Union Commission is already advanced in a number of ways in terms of accountability. The Hassan Hibre case there is one example. There are some examples of engagement with the International Criminal Court and so forth. So the role that they play is absolutely important. A final point is there could also be some space for supplementing the role that the Secretary General, Special Representative, and other stakeholders play. For instance, within the African Union, there is already a decision by the Peace and Security Council, which is a very positive one, to appoint a special rapporteur on children in armed conflict within the African Union. I have no doubt that when that materializes, probably in the foreseeable future, it will take the agenda forward, and it will put it very high on the political agenda within the organization. So I am very clear-eyed in terms of the role that regional organizations can play, based on my experience within the African Union, which is very positive.
Thank you. There's a specific question asked that I think I could answer, but I'd like, since you're the experts, I'd like to pose it to you. Can you talk about how this system relates to the problem of forced removal of children from families and forced adoptions in the course of armed conflict? Joe, was that nod a volunteer?
Yeah, I mean, this has certainly become an issue in the context of the Ukrainian conflict, and we see more and more references to this. I would just point out that, forced removal of children from their families could certainly be interpreted as falling under the rubric of abductions, which is one of the existing grave violations. So, I think we need to, look at the framework that we have and see how this can, adapt or apply to this particular issue.
Can I add that, sorry, Benjamin, just a quick word. As important, as vital as the child protection regime is, it is not the answer to every potential problem that arises. We do have international criminal law. We have accountability mechanisms in a variety of fora in that context. So I think it's unfair to look to the children in armed conflict protection regime as an answer for every issue that might arise. As Joe points out, it sounds like the forced removal of children from families amounts to abduction, which is already covered, but there will be other outrages also. They may not fit neatly into the regime that's in place at present, but there are other mechanisms that can be used to seek accountability, used as deterrence, and used as responses to problems that arise.
Just briefly from my side to say that that issue that has been raised in the context of what is happening in Ukraine. As the Committee on the Rights of the Child, we've actually engaged with it. And when the government of Ukraine just came to report to the Committee on the Rights of the Child, we engaged with the government of Ukraine. I am fairly confident that when the other party, Russia, comes before the committee, that will also be an issue that will be raised. There are already experiences in the past. For instance, the Zois Ark case in Chad, bordering with Sudan during the conflict, where a number of children were actually taken out of that area and flown to France, and that created a huge international attention and so on. Usually the rule, not necessarily linking it to children in armed conflict, but the rule is that during emergencies, adoptions are not the first port of calls. In fact, there is a rule within UNICEF that actually says, let's allow at least around 2 years to lapse before we actually start a process of adoption for children that are in these situations, because we need to identify whether or not they are children deprived of their family environments. Birth certificates are critical in these instances. And you also need to make sure that if family reunification is possible or not, and so forth. So those definitely, this happened in the context of armed conflict, but it's an issue that is within the purview of the Committee on the Rights of the Child, and I just wanted to flag that.
Thank you. We're coming toward the end of the time allotted. Can I ask, are there any closing remarks that any of the members of the panel would like to make?
Maybe I can start, and thanks again, Jerry and Harvard Law School for sponsoring this forum. I think this discussion, just underlines for me, how critical this structure is, this agenda, how important it is for children who are suffering, horrific impacts of war around the world, and the importance of all of us, whether we are UN, whether we are NGOs, whether we are academics, to really, find our, the ways that we can to ensure that the system remains operational, remains credible, and as effective as possible. You know, I think my co-panelists have said that, you know, this is a agenda that has made a real difference in the lives of children. We've seen how it can succeed. It's certainly not something that needs to be scrapped and reorganized. We just need to make sure that it works as intended. And I think all of us can play a part in making that happen. Thank you.
And fundamental to making it happen is the integrity of the listing process. So we must all renew our efforts to persuade the Secretary General and his special representative to make decisions based on evidence, to make decisions in the interests of children, and to resist political pressure that arises, because to do otherwise is to endanger a mechanism that has proven its worth in the protection of children in armed conflict. So integrity is the cornerstone of the whole system. And if we diminish or surrender that integrity because of political pressure, we're endangering a mechanism which has been shown to have value in the protection of children in armed conflict. I join with Joe in thanking you, Jerry, and Harvard Law School for having hosted this discussion this morning. Thank you.
Thank you very much. From my side, very brief points. One is, in a way, we're holding ourselves accountable as well. Last year, we spent quite a bit of time on that report, but we didn't just leave it as a report. We have engaged with the different stakeholders because we want to see the situation improve. That's one. The second point is that this is an issue that has been there for a long period of time. The children who are being victimized, they're not making an urgency on their side, an emergency on our side. That's not what's happening. These are issues that we've known for a number of years. We've known what works. We're basically asking that politicization should make way for the upholding of children's rights. The last point that I just want to ask is, and mention, whatever we've said here is a call for action. The system has worked. We want it to continue to push the boundaries. There are a number of instances that we've highlighted that are regressive measures that are undermining the effort in terms of protecting children that are affected as a result of armed conflict. If we're really serious about the convention, the optional protocol, if we're very serious about the sustainable development goals, this is actually a very good place to start.
Thank you. And let me say from the Human Rights Program, it's been our privilege to be able to have you as our guests and to put forward this very important panel. And it's been a privilege to have such an engaged audience. My apologies to the members of the audience whose questions we didn't have time to address. Thanks to you all, and let's hope that better progress is made on these issues. Thank you.
Thank you, Jerry.
Thank you.
Thank you very much. Thank you, everyone.